The decision by a grand jury not to indict in the death of Eric Garner is a miscarriage of justice. It's an outrage. It's a disgrace. It's a blow to our democracy. And it should shock the conscience of every single American who cares about justice and fair play.
We have reached yet another instance where seeking to play attorney is one of the more dangerous things we who cover the news can do, because all too often what we saw and then think we know can be turned into the stuff of riots and a greater level of misunderstanding. But it is fair to add that what we all saw in the Eric Garner case seems very cut and dried. Seems. So what are the facts? Let us seek them out. Welcome to MidPoint, former prosecutor, former assistant district attorney in Bronx County, now part of the masthead at Hochheiser and Hochheiser in Manhattan. Daniel Hochheiser joins us. Daniel, thanks so much for being here today.
Thanks for having me, Ed.
And your initial reaction when you saw the video, did you, like the rest of us, believe this was a cut and dried case?
No, I didn't think it was a cut and dried case because I have lots of experience with police cases, and I knew there would be testimony from the officer in the grand jury trying to explain away his conduct. I am very disturbed by the video and by the process by which the grand jury reached a no indictment. The public is rightly flabbergasted by this decision because the grand jury process is secret and they can't assess the testimony of Officer Daniel Pantaleo or see any of the evidence in the grand jury. So how is the public supposed to accept, just on faith, this decision, which seems to be very contrary to the clear evidence on the videotape?
Okay, I'll play devil's advocate here. Is it not necessary for a grand jury to have that complete silence, if you will, and that complete privacy, because this way nothing from the outside gets inside the courtroom normally, as it would be, to perhaps infect the proceedings or to make people think otherwise? It keeps it quiet and keeps it legal. Just a guess.
Well, it's not only that, it's part of our Constitution. So you have a right to be indicted by a grand jury if you're going to be charged with a felony in this country. So, you know, it is a constitutional rule. It may be something we want to revisit because these secret proceedings in police homicide cases don't seem to work in terms of the public being able to digest and understand what is happening in their criminal justice system.
Dan, you as a former prosecutor then answer this, if you will, because we've heard this both in Ferguson and now here in Staten Island, that the prosecutors in the grand jury perhaps dissuaded the grand jurors from making a certain decision, that they molded them to exactly what they wanted, and because the prosecutors have to work every single day with the police, that they don't want to make this stick and that they are the ones who are the problem here, not necessarily the grand jurors.
Ed, the answer is the appointment of special prosecutors in these police homicide cases. That's clear to me after Ferguson and after Garner and Staten Island. You have these relationships, as you pointed out, where the DA's office relies on the local police departments as witnesses to make their cases each and every day, day in, day out. It's too close a relationship. Even if Dan Donovan in Staten Island and McCullough in Ferguson are doing exactly the right things in the grand jury, and at least in the Ferguson situation, that's arguable. You know, it's just there's an appearance. And if you had a special prosecutor, somebody who's from another state, another jurisdiction, whose credentials are beyond reproach, I think the public might be able to swallow a grand jury decision like we saw in Staten Island yesterday.
Any doubt in your mind, though, that it does go on, that some prosecutors will indeed move things to their own agenda because they want to make sure to keep the police happy in their own community?
Well, I'll just talk about the Ferguson case specifically because I've read some of the transcripts of those grand jury proceedings. I haven't read all of them, but I've read some of them, and it was clear to me that, even though I did agree with the ultimate result, that the district attorney had a certain view of the evidence and questioned Officer Wilson and other witnesses in a way to move the case in a certain direction. And that's what prosecutors do in every grand jury. they have a certain view of the case. They're human beings. They have biases. They have opinions. And they craft the evidence to reach the result that they think is just.
All right, now, if you would stand by for just a couple of minutes, break. Much more to cover with attorney Daniel Hochheiser, beginning with the Cleveland case of a 12-year-old being shot and killed while carrying a toy gun. And now the Justice Department is getting ready to make a statement on that case. We're right back.
In the park by the youth center, there's a black male sitting on the swings. So he keeps pulling a gun out of his pants and pointing it at people.
Radio, shots fired, male down, black male, maybe 20, black revolver, black handgun. I'm sending EMS this way.
Let's welcome back to MidPoint former Assistant District Attorney in Bronx County, now at Hochheiser and Hochheiser in Manhattan, Daniel Hochheiser. Dan, let's go ahead. Before we get to the Cleveland case here, just one thing I want to bring back from the Eric Garner case. From anything that you have seen and read here, do you see any reason for a potential civil rights violation finding in this case? Because the Justice Department will be looking at it.
No, because they won't be able to establish the necessary element of intent on the part of Officer Daniel Pantaleo to kill or injure Eric Garner. So no, there won't be a civil rights indictment federally. I'm not sure what they're going to investigate based upon the same evidence that the grand jury had. So no, I don't think that's going to bear any fruit. I think it's going to be another disappointment for the Garner family.
Let's go back now and turn to the Cleveland clip that we just saw here at the top of the segment here. 12-year-old boy. Apparently, they're saying that the cop involved here who shot the young boy was deemed unfit for duty at one time. But from what we see from that videotape itself, do we see enough to leave beyond any shadow of a doubt that this officer acted irrationally or did something illegal?
No, you have to hear the officer's statement. You have to have him testify or be interviewed to know what was going through his mind, which caused him to shoot this 12-year-old boy. What I know of the facts, which is not that much, I've seen the video, and I understand that this little boy had a toy gun, which perhaps had the orange tip of it taken off the gun, so it looked maybe like a real gun, and that's a real problem, and that is an issue really of parental supervision, and it's a tragedy and horrible, but you know, police officers are doing a very dangerous job, and when they encounter people who look like they have what appears to be a weapon, they have really a split second to make a decision about whether to use deadly force or not.
And what about those people who say that police officers are charged with protecting the public and serving the public, and in a situation like that, they need to take that extra second. They need to stop. They need to consider it and do everything they can to ensure that they do not shoot anybody?
Well, I think that's just not practical, and I have never been a police officer, but I've known many. And my understanding is that when you're in those kinds of situations where you're encountering a suspect and there's dark lighting and somebody appears to have a weapon, you really don't have a lot of time like we're doing now, Ed, to analyze the situation, think through all your options and try to make the best choice. You have to make a split-second decision, which is hopefully based on good training and experience. Perhaps this officer in this situation did the wrong thing and acted too quickly, but I don't know enough about the facts. I haven't heard from this officer, so I'm going to reserve judgment on that.
All right, I got about a minute 30 left here. Wanted to ask you about one more legal case, if you will. The appeals court in Austin, Texas, actually I should say in New Orleans yesterday, stayed the execution of the Texas man, a case that has gained national attention. They were going to put him to death. Apparently, he represented himself at trial, wore a cowboy costume with a purple bandana, trying to call more than 200 witnesses, including John F. Kennedy and Jesus. What is your take on the appeals court basically setting this aside and setting aside the execution?
First of all, Ed, I wish I could call Jesus in one of my trials. That would be very helpful. But on a serious note, I think, I don't really see how reasonable people can take the position that we should be executing insane, schizophrenic, delusional, crazy people who don't understand reality. I don't think that that's what America is about, to punish sick people and kill them. I just think that that's wrong. I think it's a violation of the 8th Amendment, cruel and unusual punishment clause of the Constitution. And I hope that the Supreme Court, which I believe heard an argument on this yesterday, does the right thing and takes this off the table.
Well, we only got about 20 seconds left. I know you're in New York City. Is the city calm today?
The city is calm today. You wouldn't even know that anything happened in Manhattan, at least downtown and Midtown, where I've been today. Last night I was going past Grand Central, and there was a huge militarized police presence, and I understand there were people laying down in Grand Central doing a die-in. So there was, and they had a situation by the Rockefeller Center where they're going to put up the Christmas tree, where they had huge traffic problems, and it was a bit of a mess, but things haven't quieted down. Unfortunately, everybody was peaceful.
But peaceful process and peaceful protest is good. Daniel Hochheiser, thanks so much for joining us. We'll look forward to talking to you again, and MidPoint will continue.